Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property lawyer at 1LLP, and I am glad that you are law curious. We aim to explain and contextualize the legal system in easy-to-understand ways. Just the facts. No partisan spin so that you can get it straight. Today we are looking at free speech and when inciting words trip lines and become unlawful. We will look at the seminal case in this area and also a recent case involving former President Trump. What is free speech under the First Amendment? Let's start with the amendment. Here is what it says. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. It covers freedom of speech, religion, assembly, and the press. But today we will talk only about the speech clause. By its terms, it originally applied to the federal government, but after the Civil War and the adoption of the 14th Amendment, it was applied to state and local governments too. So today, it applies to the government at large. It does not apply to private entities. That is, you do not have free speech rights in a McDonald's. McDonald's can regulate speech in its private business in ways the government cannot. The key point, the First Amendment stands to restrict government behavior, and private universities cannot be sued under the First Amendment either. Their speech codes are not acts of the government. But public universities are subject to suit for tripping the First Amendment. That is the first important fault line. It says practically, government shall make no law abridging the freedom of speech. Does it really mean that literally no law can be passed? Does it really mean that government cannot restrict speech at all? Notwithstanding those words, it does not. The Supreme Court is under our Constitution the entity that defines the meaning of the Constitution and its words. It is held that the government can regulate speech subject to tests to decide whether the restrictions are acceptable. This is why government laws that prohibit false advertising, which is speech after all, are lawful. Why threatening someone's life, which is also speech after all, can be regulated by government laws, civil and criminal. So the second point, the government can impose certain limitations on our speech. What about speech that tends to incite violence? This is the core area that finds itself being fought over. Did someone, say a famous politician, seek to create a riot or violence, or were they just speaking about policy in animated ways? The Supreme Court has developed a test to evaluate this kind of speech, a test from the 1960s in a case called Brandenburg versus Ohio. Let's discuss it a bit. Here are the facts. In the 1960s, a man named Clarence Brandenburg addressed a gathering of KKK members in Hamilton County, Ohio. During the speech, which was recorded by invited media representatives, Brandenburg discussed the fate of the, quote, white Caucasian race, end quote, at the hands of the government. He made anti-Semitic and anti-black statements and alluded to the possibility of revenge or vengeance if the federal government and court continued to, he said, quote, suppress the white Caucasian race, end quote. He also announced that the Klan members were planning to march on Washington, D.C. on Independence Day. He was arrested and convicted of advocating criminal activity or unlawful methods of terrorism in political reform. He argued his speech was protected under the First Amendment, and the state could not convict him under a state law, because the law as applied to his speech violated the First Amendment. The U.S. Supreme Court unanimously reversed Ohio's conviction, finding his speech protected. The rule the Supreme Court adopted applies today as this. Number 1, speech can be prohibited if it is, quote, directed at inciting or producing imminent lawless action, end quote, and number 2, if the speech is, quote, likely to incite or produce such action, end quote. For shorthand, this is known as the Brandenburg test, and essentially it allows speech to be regulated if it is speech aimed at producing an imminent lawless action and likely to incite such lawless behavior. Brandenburg's speech, although nasty and racist and inappropriate, did not actually meet that test. That then is the core test that still applies today in the 21st century. So let's look at political speech from recent times and how it plays out in our modern cities and towns. We will look at a lawsuit filed against former President Trump for speech he made at a rally while he was running for the presidency in 2016. Here are the facts. At a political rally he held for his candidacy in 2016 in Kentucky, several opposition protesters were present and agitating against him. In response, former President Trump said to, quote, get them out of here, end quote. They got beaten up, they claimed, as they were removed by the crowd. They sued for inciting a riot under Kentucky law that made it a misdemeanor to incite a riot. The Federal Court of Appeals held that he did not specifically advocate imminent lawless action. It said, quote, "The words were said at a campaign rally by the main speaker in response to disturbances caused by protesters. The words were self-evidently said in order to quell the disturbances by removing the protesters. The words were directed to unidentified listeners in the convention center, among whom most were Trump supporters who were not sympathetic with the protesters. In the ears of some supporters, Trump's words may have had a tendency to elicit a physical response. In the event a disruptive protester refused to leave, but they did not specifically advocate such a response. As a result, the Federal Appeals Court held that the speech was protected within the Brandenburg test, and Kentucky law could not make him liable for the speech. So this test in action even today is seen right there. His speech was protected by the federal courts, and he could not be sued or prosecuted for it. What about government regulations of hate speech? Here is a famous case that has stood as an example of how we must tolerate speech that we find offensive or hurtful. It's the 1970s in Skokie, Illinois, a town that was a particular beacon for survivors of the Nazi concentration camps. The National Socialist Party of America wanted to hold a protest in the city one day. It had made hateful and racist comments about Jewish people and people of color. It sought a permit to hold a rally in the town while dressed in Nazi outfits. The Illinois Supreme Court then ruled in favor of the National Socialist Party. It held that under the First Amendment that, quote, "public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers," end quote. The point when it comes to offensive and hurtful speech from the courts is this: we must, in a free society, listen to things we do not like and disagree with. Government cannot start down the path of censoring speech because of its viewpoint. After all, if you start down that path, then pretty soon government will be able to regulate all manner of viewpoints. For this reason, the Supreme Court has taken a strong stance on this rationale for not letting government engage in what is called viewpoint discrimination. Here's what it has said, quote, "If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable," end quote. So there you have it, a quick overview of the First Amendment in the area of speech that may incite violence, or speech that can be deemed hate speech. You have seen how our First Amendment works, and some of its basic principles and tests in this area. Now there is a lot more, of course. Law students study just this amendment at length and still scratch the surface. As lawyers, we litigate cases over it as it touches all manner of conduct in our lives in countless different ways. But this gives you a brief overview of some of the core issues. If you want to dive deeper, we have a series of 1-hour programs you can watch that discuss the First Amendment in more detail. You can watch a 1-hour program on the First Amendment, you can watch a 1-hour program on hate speech, and we have a 1-hour program on the Vietnam War and how it created myriad significant First Amendment cases. Just follow us, please, and subscribe to this new media legal publishing channel on YouTube. Thank you for being law curious and watching.